think in order for an attorney to practice securities law, that attorney has to have some basic background and understanding of what the laws are, and that typically would be in the form of training and education, whether it's in law school or a specialty certification after law school. And the second component of this would be experience. You need somebody who has experience prosecuting or defending claims involving securities law. And that's a wide breadth in and of itself. We handle the civil side of securities issues, whether that's the plaintiff or for the defendant. And we understand all the other related claims that are in the basket of securities litigation, whether that's securities fraud or fraud in general or breach of fiduciary duty or negligence, for example. Additionally, I think, in this area, you would need experience with arbitration proceedings because a lot of securities issues on the civil side are related through very specific FINRA arbitration proceedings and other arbitration proceedings outside of the FINRA process. I think some of the red flags that a business owner should be aware of when selecting counsel is the amount of experience that particular lawyer has in the field. So for example, if I'm a CEO and I've been hit with a securities fraud allegation that's pretty material and scary, I'd want to ensure that the counsel I select has experience defending that particular type of claim. And I would want to know the success record or failure record of that counsel. And I would caution clients or prospective clients, like business owners in that situation, from simply going with a generic brand name law firm. There are some great boutique law firms out there that have excellent training experience and reputation in the field. So I would look at experience, I'd look at training, and I'd look at actual data, if possible, regarding that lawyer's experience in dealing with defending or bringing the type of securities claim that the business owner is faced with. There's different ways to look at actual data. Oftentimes, over 90% of the times, civil matters are resolved via settlement, and those settlements typically have confidentiality provisions. So unfortunately, there's times when attorneys cannot share the results of an underlying case with the client, whether it's on the plaintiff side or the defense side. Having said that, there are cases that go to trial to verdict, and those are readily shareable. They're on the case dockets, whether it's federal court or state court, and there's different search engines out there that allow you to research a firm's success rate or failure rate in the world of obtaining verdicts or settlements. Some of that software is pretty nuanced, and it's not necessarily the most user-friendly as it relates to the general consumer or the public, but it's available. The biggest pitfall that I've seen with attorneys involved in the securities world is raising funds for prospective clients or clients. We as lawyers cannot do that. By definition, we would need a FINRA license or an SEC certification through the Series 6 or 7 exams and other exams and certifications. And we don't have the training experience. For the most part, there are some lawyers that do, but for the most part, we're legal advisors. We're not investment advisors, and we don't have the ability to raise funds. So the biggest issue of concern for me as a lawyer is giving ethical advice to a client who's trying to raise funds, and if I'm ever put in a position where the client has asked me to raise funds, I've got to politely decline that, and because I don't think lawyers have a role in doing that.